The caveat to this is everything I tell you today won't be correct tomorrow. The law changes on a daily basis, and so we struggle to keep up as well. So in the next 15 minutes, let me unpack as much of this as I can. Let's start with the history. So America has a long tradition of controlling its borders, and up until 1952, there was a whole series of acts, the Chinese Exclusion Act, etc. But 1952, 1965, all of those various acts were codified under one statutory authority. So Chapter 8 of the United States Code is where you will find immigration law. And by the time we got to 1965, all national distinctions, all racial distinctions were eliminated, and the United States decided they were going to go down a two-tier system, which is skilled labor and family. So skilled labor had a priority and a set of visas, and family members had a set of visas, and that's the system that we use today. Now, all of that, if you can think it, 1952, was predicated or based on a turnstiles entry and the concept of a lawful admission to the United States. So if you think of somebody coming to the turnstile with either a skilled labor job or family and making an entry, so that term of admission was the basis for everything that, all the law that followed that. The problem is it did not contemplate a mass undocumented entry in the United States. So the law rapidly became corrupt in its attempt to accommodate for the reality or the facts of what occurred. So the biggest problem with immigration law is, yes, it's complex, but it's complex because it just doesn't work. It has not been adequately updated. It would be as if you were still running, I don't know, display right on your PC, and it's just not going to work. The immigration law is a federal administrative law, so we've talked somewhat about statutory authority and who has what. So you take the United States Code and you hand it to an agency. In this case, the agency right now is the Department of Homeland Security. And the Department of Homeland Security oversees three separate individual agencies: Immigration Customs Enforcement, United States Citizenship and Immigration Services, and Customs and Border Protection. Part of immigration is also doled out to the Department of State, because the Department of State is duty-bound to issue visas to non-citizens who are outside the United States that want to come into the United States. And lastly, the Department of Justice, who used to operate all of the immigration law except for the Department of State prior to 9/11, now is the court system. So when we have someone who is subject to being removed from the United States, they can go see an immigration judge and go through an immigration removal proceedings. That court system is run by the Department of Justice. So when you think of family and labor, what you're looking at is a visa system that is based on a priority date, and the date is when you file. So if you're filing, for example, a United States citizen can file for their brothers and sisters. And brothers and sisters have a limitation of 65,000 visas every year for the entire world. So that's created a backlog. And some countries file more than others based on population. So when you look at the visa bulletin, that chart that decides who's going to come in when, it's broken down into all of the world, and then it's broken separately down into Mexico, China, India, and the Philippines. So as an example, in 1974, my wife, her father, mother, and her sister all came over to the United States on a brother-sister petition. My mother-in-law's brother applied for all of his sisters and their family to come to the United States. So that visa process from filing to a visa availability and the entry to the United States in 1974 took 4 months. Right now, if we were to look at India, the country that they're from, that same category is basically stagnant. It's stuck in 2003, in July of 2003, hasn't really moved off that mark effectively in the last 2.5 years. So if you filed after 2003, you're not coming anytime soon. And if you filed today, a rough guess would be that you would have about a 28-year wait before your visa would become available, based on looking back at that analysis. In a business perspective, if you're running a business and you need to bring in a skilled worker, one of the most common skilled worker visas is a non-immigrant visa known as the H-1B. And it just recently got a lot of great press on 60 Minutes the other day. that H-1B is also limited to 65,000 visas a year. That usually gets applications that hit April 1. So all your business attorneys aren't answering their phones right now because they're busy. But this year it's April 3rd, those applications are due for a start date of October of this year. So you as a business owner have to file in advance for someone who's not going to start until October. The problem is you have 35,000 openings or visas available, and 220,000 applications are going to hit immigration in that first day or 2 days. So what they do then is they take a lottery of those visas, and they just pull them out randomly, and those are the applications that are going to be examined. And if they're correct, you get a visa. If they're not, you get a nice letter that says your application wasn't selected this year. So you as a business owner can't plan for that. If you want to bring someone in permanently, since an H-1B visa is a non-immigrant visa, meaning it's limited in time and scope. So an H-1B is limited to 3 years. You can renew it after 3 years, and then it's renewable every year after that, depending on the type of job you have. So if you want to bring them here permanently, we're back to that same chart that we discussed about brothers and sisters. So if we're back to an Indian skilled worker, someone with a bachelor's degree, which would be the comparable to an H-1, you're going to have a wait period of 10 or 12 years before that person is going to have a visa available for them to come to the United States. So the question then becomes is how do you plan to bring in foreign workers? The answer is effectively you don't, unless you've planned well ahead or you're hiring folks with higher degrees. That's the simplistic part of it. That's the rudimentary system that operates. You file an application based on a relationship, whether it's either family, as if this side of the room is family, and this side of the room is business, depending on what you're trying to do. So what happens then if you have someone who's here without permission? That depends on what you're trying to do. If you're trying to file under a business because you've hired someone, you realize they have no status in the United States, but they've become a valued worker to you, you're out of luck. Because the business side doesn't have any way to forgive either their unlawful presence or their unauthorized employment that they've engaged in, that they've been here in the United States. So we have 11 million people, if that's the statistic that we're going to use, that are here without permission. And they're here either in one of two scenarios. They've entered the United States without permission in the typical border crossing method. Or they've come legally on a visa and they've overstayed it. And they've then, once their visa, the permission to be in the United States expired, they've now begun to accrue what's known as unlawful presence. And you, as a business owner, you can't hire them because they have unlawful presence. Family, you have a few options. Depends on who they are to you. Are they your spouse? Are they your parent? Are they your child? If we go back to our 1952 analysis, it's probably rational to consider that the government thought of a patriarchal system where the father comes into the United States, brings the wife with him, brings children with him, because that was the culture of that time. So what we found now is that the system didn't keep up with the population. And what we're finding now is we have a population of adult citizen children who have very little that they can do for their parents, depending on how they enter the United States. Because if you've been in the United States for more than a year without permission or after your visa expired, you're now subject to a bar to being allowed permanently in the United States. And that bar is 10 years. And that 10 years is outside the United States. So if you're a parent who came without permission 22 years ago, and you had a child who's now 21, and the child wants to apply for you, you have to leave. It's kind of like the movie theater analogy. If you go to the movies, you buy your ticket, the 12-year-old tears it in half and tells you to go to theater 6. You get some popcorn and head over to theater 6 and sit down, and you realize that you've been duped by Rotten Tomatoes, who said this was an excellent movie, and it is the most horrible piece of cinematic stuff you've ever seen. Then you go to the manager. Even if you suffered 20 minutes through this movie, even if the movie has already begun, you watched all the credits or all the previews, and you watched 20 minutes of the movie, you still have a ticket. Even though it's now effectively expired, You can go back to the manager and say, that is a terrible movie. I want to go see Star Wars. And the manager will change that ticket for you because you had permission to be in his theater. Now, what he's doing effectively is he's changing your permission to be in the theater from the terrible movie in 6 to the good movie in 7. If you didn't have that ticket and you went to the manager and said, I want to go see the movie in theater 7, what's he going to tell you? Get out of my movie theater, go to the booth out front, buy a ticket, and then come back in. And we'll think about letting you back in because you snuck into the movie theater. So those parents who entered without permission want to stay here. Their children who are adults and citizens of the United States want them to stay here. But the problem is the law didn't keep up with that population. And so the waiver, the forgiveness for that unlawful presence can be given by a spouse or a parent who's either a resident or a citizen. Well, notice there's no child there. So if you'll remember, a few years ago, there was a term bantered around called anchor baby. Everybody comes here, has a child, and it gets to save them. The problem is in the law that it doesn't. Now, if the parent came and had a ticket, if they all came on a visa and had a child born here, and now they're 21, that's a little different. The change of status in the United States can be accomplished because they don't have to leave. And leaving triggers the bar. When you walk out of the movie theater, the question is, are they going to let you back into the movie theater? If you don't leave the movie theater and you're changing your ticket, well, then you get to just change your ticket inside the movie theater, and there's no penalty. That's the basis of that family bar, that family issue to immigration. And so when we're talking about lines, which is the wonderful soundbite, is just get in a line. It depends on what line we're talking about. And it may be that you can get in the line, but your wait is 20 years. It may be that there is no line because you don't fit into one of the categories that we created back in the 1960s. And so there's no way for you to stay in the United States. There were some questions as the day was going on. One question was, can the president tell a particular agency not to follow the law? Another lovely soundbite out of immigration, which is to say that the president told people not to enforce immigration law. That's not exactly true. The issue was that what was being done was a discretionary application of resources. And what was being told is to focus on criminal non-citizens, not non-criminals, non-citizens. So people who just accrued unlawful presence are not criminals. So let's clear that up. If you're here without permission in the United States, and you've walked across the border, through the desert, across the Canadian border, whichever, the minute you crossed the border, you committed a misdemeanor, a federal misdemeanor. That act of entering was a misdemeanor, much like not driving without your driver's license is a misdemeanor. And that's the only crime that you committed. Your presence here is not criminal. It is an administrative violation. It is a civil violation. You have broken a civil law, but you are not a criminal. If you are here without permission or out of status, you came on a visa, your visa expired, and you're now still in the United States, you overstayed your ticket, that's still a civil violation because this is all administrative civil law. You are not a criminal. The only time your presence is criminal is if you have been through the system, the agency deported you from the United States, and you were removed. And then you returned without permission. At that point, your presence in the United States is actually a crime. So the concept when you say people are illegal is a tag phrase to make it sound criminal, to make it sound worse than it is. But it's a civil violation, yeah, also. Okay, so let me unpack all of the pieces of that question. If you're not a citizen of the United States, whether you're here lawfully or unlawfully, crimes that you commit may have consequences to your immigration status. You can have a green card. You can be a lawful permanent resident of the United States. And if you commit a crime, that can be used to remove you. And it depends on the type of crime. And so the reality is not, is it a felony or is it a misdemeanor? The reality is not, is it violent or nonviolent? Is that crime either specifically stated in the Immigration Act as having a consequence, or does it fall into a classification of crimes that cause an immigration consequence? So briefly, let me unpack 3 terms for you. Crime involving moral turpitude, a crime that's bad because it's bad. So if we get into a disagreement over this, and we're having a glass of wine, and we get into a shoving match, our physical contact could be construed as a crime. It's a battery to touch someone in a rude, angry, or insolent manner. But is that a crime involving moral turpitude? No. If I take the wine bottle and I break your nose, that's probably a crime involving moral turpitude. The second term is aggravated felony. An aggravated felony is a statutory term. It's defined in the Immigration Act, and it is a group of cases, it's a group of crimes. But they're neither aggravated, nor are they necessarily felonies. In the state of Kansas, if you commit a theft, you steal something, the maximum sentence that you can get is 12 months for that misdemeanor crime of theft. But yet a theft offense that you've been convicted of and received a 12-month sentence, even if you don't go to jail. So the term is underlying. You go see the judge. The judge says, I sentence you to 12 months in jail. I'm going to stay that sentence. I'm going to suspend it. I'm going to give you 12 months of probation. Go do your probation. Think of the probation as a frozen lake. If you stay on the frozen lake and do just fine, then you walk all the way across it and you're done. You never had to get the sentence. But if you jump up and down and cause a lot of problem and the ice breaks, what do you fall into? You fall into that sentence that underlay your probation. So that's your underlying sentence. If you have a crime, a theft offense, that you got sentenced to 12 months, that's an aggravated felony. And that gets you removed from the United States. So the analysis of what crimes affect a non-citizen is a specialty, and it's one that we do at the firm that my wife and I have. But it's the subject of much litigation. So that's kind of the short answer, is it depends on what the crime is. The one that shocks everybody is that a DUI offense makes you a target for immigration, but doesn't have a statutory effect on your immigration status. Now, we can sit and debate. There are some nuances to that, and I'm not going to get off into the weeds, but that doesn't have a statutory effect on your immigration status. But it does cause you to be targeted by immigration. I think I'm way out of time. If there's any other questions, we'll take them. Otherwise, I'll be here for a little bit. Yes, sir. It depends on what you do. So the question was, if you get a job and you're in an unlawful status, is that a crime? If, as Allison had said, you've used a Social Security number that's not yours. But if you come into the United States as a student, your visa allows you to go to school, but it doesn't necessarily allow you to work. But you get a Social Security number, or usually do, because it helps with the accounting of your student fees and any other grants that you may get. So now you have a Social Security number. You have a valid visa, you can go get a driver's license. So you show up at work and you go, well, I have some documents, can I have a job? And they go, sure, fill out this I-9 form. Well, the only box that you could check would be one that says either you're a citizen or you're a national of the United States. If you falsely claim to be a citizen on that form, you've committed a crime, 18 U.S.C. 911, but you've also now endured a permanent bar to the United States. If immigration officials figure out you check that box and claim to be a citizen, I don't care if you're married to a citizen, I don't care if you're the parent of 10 citizens, you're barred permanently from the United States for that. Any other questions? Yes, ma'am. That's correct. It's even more simple than that, but yes, it does. We don't have a national ID card. We get paranoid when people say, let's have a national ID card. But the YARC required, since you're a non-citizen, to carry proof of your status in the United States, which also becomes awkward if your status is your passport and the visa contained within it. But it does lend somewhat, but I think the more pressing question is they don't even ask for what is your status, show me your green card. They say, what's your social security number? And either you have one or you don't. And that basis is the basis on which municipalities in the area will discriminate against people, whether you've been convicted of no driver's license or you've been convicted of trespassing and you're asking for probation. They'll go, what's your social security number? If you don't have it, then your probation is different than someone who does. So it doesn't necessarily even become as insidious as the green card. It's down to, can you give me your valid social security number? Any other questions? Yes, sir. Most people make up a number, or they go see someone at one of the flea markets in the area and under the table make a deal, and they get given a card of some kind. There's a number of cultural nuances, whether you're African or you're Mexican or you're Hispanic or you're Asian, depending on where or how that document is created. Any other questions? Right. That's a giant question. What she's referring to is there was an interior flight in the United States. So it didn't arrive from the outside. It was, it's domestic flight, Kansas City to Miami or wherever it was going. And when people got off the plane, a CBP officer was asking for ID from everyone because they were trying to identify an undocumented person that they thought was on the plane. I can't even begin to describe the problems with that scenario. The first of which is, you asked me if I was, were you looking for a Canadian? Because otherwise, why would you think I or Allison or anybody? What did you not have even a physical description of whom you were looking for that caused you to ask everyone for ID? Or did you think that there are some scenarios where for example, and Jerry can help me, in a roadblock situation, you stop every car. You can't just say, no, I like that one. Unless you've got a reason to stop that particular vehicle, you have to stop everyone and filter them as you get them. And that may have been their thinking, is it will just filter everyone on the plane. But that doesn't make a whole lot of sense if you're looking for someone of Hispanic or a non-generic Caucasian. You didn't even have gender down because they were asking everyone for ID. So that, exactly. And I don't know what the thinking was. CBP is normally pretty tight-lipped about that, and I haven't heard anything more about it, except it was that isolated incident. But yes, I don't have a clue, and I don't know how I would have responded. I think I would have looked funny and gone, really? I don't think so. Arguably, yes, because you were screened not by law enforcement. Now, there is a caveat, at least in my understanding, that if a law enforcement officer says, who are you, you're required to identify yourself to them. Now, at the end of that, you get to go, am I free to leave? Then you're free to leave. So that may have been a possible response, Kay. Which officer? Depends. As Jerry said, the Constitution is pretty clear. The word citizen is only used in a couple of places, and none of that is contained within what we're discussing here. The Constitution refers to people. So they have a certain right to refuse, as any other child would have to refuse to go with law enforcement. Do they have probable cause? If they're a non-citizen student, does whoever is taking them And that begs a whole different question. If it's an immigration agent dealing with a non-citizen child, does that person have a reasonable suspicion to believe they're not a citizen of the United States so that they can then exert their administrative authority over that non-citizen? Because remember, if you're talking about an immigration official, unless an immigration official thinks you committed a crime that's within the gambit of what they can enforce, which would be federal law, then they have no jurisdiction over you. Their jurisdiction is over federal crimes. Just like if I go into immigration court and I assert my client is a citizen by derivation because their grandmother was a citizen and then maybe their mother a citizen and now that actually makes them a citizen, then what I'm asserting is that the court doesn't have any jurisdiction over my client because it's that narrow scope of what that court or what that officer can enforce. I thought I saw no. Yes, ma'am. The boots on the ground policy right now has reverted to about 2006, 2012. That's a Bush transition to Obama era. So what that means effectively is that everybody who's a non-citizen is subject to removal. To give you an example, little old lady gets stopped in Emporia for no driver's license, get arrested by the police. So the police department puts that person in the Lyon County Jail. The Lyon County Jail contacts immigration. Immigration says, yes, we want them. So 2 ICE agents drive from Kansas City to Emporia, picks up the 60-year-old woman, takes her up to Kansas City, fingerprints her, issues her a notice to appear in immigration court with just a charging document, and then says, okay, see you later. Happy trails getting back to Emporia because they released her without a bond, or without the need of a bond on her own recognizance. So that's the boots on the ground enforcement policy, as opposed to 2014 when Jay Johnson created a priorities memo that said criminals, national security, gang members are tier 1, felons, DUIs, domestic violence, tier 2, people who are recent border entrants are tier 3, and then everybody else isn't really an enforcement priority because we're focusing our enforcement priorities on those folks. We have quite a nationalistic exclusion concept going on, seal the borders. Senator Graves is a big fan of adding a bill in every once in a while that says we're going to stop all immigration. I don't know where we are going forward. And I'll close because Lena's really getting antsy in her chair here. The H-2B non-immigrant visa, so the guys mowing the lawns, it's a non-immigrant visa on a temporary basis, so it's seasonal work. So you're usually coming in from March to November. 65,000 visas are issued for the entire United States in that category. Lots of guys and gals who run seasonal businesses don't get their people. And usually what occurred in the past was if you got your worker in and they came in, they worked March to November, and then they left, and then you wanted them to come back, when you applied for that returning worker, they didn't count against the 65,000. You could just apply and you would get that person back. Well, they've changed the rules. Now that person applies against the 65,000. So now your returning worker counts against the cap, so you have less of a chance of getting the worker you know is skilled as opposed to anybody else new that you're bringing. So in some way, those rule changes are going to cause us to be a more restrictionist environment.